I think we are good to go ahead and get started. So, thank you again, everyone, for joining us today. My name is Amanda Fisher Pinner, and I'm over here at the Miller Group, and we have a great discussion set for today. Before we get started, I just have a couple housekeeping items to go over. First, everyone is muted, so we should have some time for Q&A at the end. If you have a question, just pop your question into the chat. You can send that to me privately, or you can post it to the group chat if you want to, whichever you prefer. But just keep in mind that the session is being recorded and we are somewhat limited on time. So please use discretion when asking a question and know that our panelists can't give specific legal advice during the session. And we definitely want you to be careful to not jump into too much detail about a unique situation if you have a question. So just keep that in mind. And so without further ado, I have the honor of introducing our moderator today, Shannon Hilding. Shannon is our president of property and casualty at the Miller Group, and she has over 10 years of experience in insurance, and she also has a background in law and compliance. Shannon specializes in liability subject matters and placing insurance coverage for our clients. So I will pass it over to you, Shannon.
Thank you, Amanda. Thanks everyone again for joining us today. I'm going to introduce you to our three panelists. So our first is Chelsea Mam. She's an attorney at Bryan Cave. Chelsea, could you share with us your practice area?
Yeah, thanks. Thanks, Shannon. I am a general litigator on complex civil litigation, but one of my focuses is on policyholder recovery work on behalf of insurance. People who have insurance and want to sue their insurance company. It's where I get to wear the white hat.
Thanks, Chelsea. We call her coverage counsel, so you might hear me refer to her in that way throughout this webinar. So our next panelist is Michael Judy. He's a managing director at Dysart Taylor. Michael, could you share with us your practice area?
Yeah, perfect. Thanks, Shannon. I'm a trial lawyer on the defense side of things. So I'm the person who represents defendants on the other side of all those folks who are advertising on TV for needing a lawyer. My two primary areas that I practice in are transportation and then retail and hospitality. Transportation is obviously, trucking cases, catastrophic losses, and then on the retail and hospitality side, that runs the gamut from foodborne illness to slips and falls to pretty severe negligent security claims. So again, appreciate the opportunity to be with you all today.
Thanks, Michael. So I'll just refer to him as defense counsel kind of throughout this as far as is his role for this conversation. Our third panelist is Scott Jensen. He's Executive Vice President and National Construction Practice Leader for Casualty Insurance at Amwins. So Scott, could you share a little bit about Amwins and your role there?
Yeah, so I lead up the construction practice under the casualty umbrella. Been doing it for 20 years, and what we specialize in is just liability placements, both from a general liability and excess liability placements. So we're here to help in all facets of placements for anybody from construction, real estate, and transportation.
All right. So we call Scott a broker to brokers. So Miller Group is a broker, and Scott helps us broker kind of some of our hairier risks. So he'll be giving kind of an insurance broker perspective for this conversation. Okay, so let's go ahead and get started. So the definition of nuclear verdicts, why we're here today. So technically a nuclear verdict is defined as a verdict of $10 million or more. But for today's purposes, we're going to go ahead and broaden that definition. And we're just going to talk about verdicts or settlements that come in higher than we would ordinarily expect. So we've defined a nuclear verdict, but there's some other buzzwords that we hear around the nuclear verdict conversation. So we want to talk about some of those and their implications. So we're going to start with a judicial hellhole. So Michael, would you mind defining what a judicial hellhole is?
Yeah, absolutely. So in general terms, judicial hellhole is a jurisdiction, a county, federal court that returns large verdicts for plaintiff and/or is generally unfavorable to a defendant. It's a place where if you're on the other side of litigation, you don't want to be, and you want to get out of there as quick as you can, if you can. There's a lot of different reasons that a jurisdiction can be a judicial hellhole. It can be the makeup of the potential jurors. Metro areas are typically worse than rural. Think Philadelphia, New York City, big cities are tough to be in, but that's not always the case. Places like Brownsville, Texas, or West Virginia as a whole are considered judicial hellholes. And it can be, again, because of the makeup of the jurors, but it also can be the laws of the state or the judges on the bench. It's particularly true in a lot of states where the judges are elected and heavily influenced by the plaintiff bars in those states. It's hard to rule against a lawyer in a case if he or she's been providing your campaign with a lot of money or donating to the particular judge. But as far as kind of why it matters, using the state line between Missouri and Kansas as a good example, the laws in Kansas are much more favorable to a defendant than Missouri. And comparative fault is a pretty good example. You can take a case, and I don't want to get too far into the weeds here, but same facts, same liability, same comparative fault on the part of the plaintiff. And in Kansas, you'd get a defense verdict or have a really good shot at a defense verdict. Whereas in Missouri, it could be a potential six-figure verdict. That's because Kansas juries are a lot more conservative in terms of jury awards and the law is more favorable. But it also depends, in the state, county to county varies. You'd rather be in Johnson County than Wyandotte County. You'd rather be in Cass County than Jackson County. And we'll kind of, at least I will touch on this theme a lot through this, but as you work through the litigation process, it's really important to be in communication with not only your lawyer, but your insurance carrier, your broker, to talk about those different exposures so you have a good idea of the lay of the land as you enter into litigation.
Yeah. So Chelsea, as coverage counsel, what's your perspective on choosing where to potentially file an action against an insurance carrier?
Right. So for my practice area and when I'm thinking about my clients and their coverage, obviously I have to consider the legal issues about where to place the litigation against the insurance company. But certainly if I can get my client into a jurisdiction that's more favorable to a policyholder, I will do that. So there are several jurisdictions that are known to be more favorable to policyholders, like Washington, where I practice primarily. But I practice everywhere, and I've had cases in California that tend to go well. Illinois is very good for policyholders. On the other hand, states like Florida, Alabama, New York are less favorable. They tend to favor insurance companies, and we will do whatever we can to get our case out of those jurisdictions and somewhere else if it's possible, given the circumstances. And we obviously have to take into account where the loss is and if the policy has anything to say about that issue. But we always are considering what's the best place to file a lawsuit if we have to.
Yeah. So Scott, as an insurance broker, what do judicial hellholes have to do with insurance?
I mean, the key to the judicial hellholes is if you're doing work in those either states, cities, or counties, the underwriters are going to take that into account and how they're going to underwrite you. And in your vast experience of being in that class of business, while, as Michael kind of said, in Kansas, you're seeing favorable, and in Missouri, you may be seen unfavorable. So the underwriters have that. So it's why they ask, where are you doing business? What kind of business you're doing? Because when they take that into underwriting, a favorable claim in Kansas makes you going to be way more favorable to underwriters and having more carriers want to participate on your account versus if you're doing something in Cook County, Illinois, there's going to be a ton of carriers going to be like, hey, we have not found our abilities under any class of business to be able to be profitable in underwriting in that county. So knowing what counties, what states, what cities you're involved in is going to help the underwriter make a better decision for profitability of your account, but also their overall book in that class of business.
Yeah, I agree. So another term we keep hearing bouncing around is third-party litigation funding. So Scott, would you mind defining this term and explaining why carriers are concerned about it?
Yeah, so litigation funding is basically an arrangement where a third party comes in to a lawsuit in exchange for financial gain and basically agrees to fund a local lawyer or firm in a case to basically say, hey, we want to bring this case all the way to a jury case. And basically it says like, where if you have a local firm who's not very well funded monetarily wise, we now have a investment mechanism. Some of them are publicly traded on the New York Stock Exchange, and says we're going to see this all the way to fruition and get the most amount of money. And it's a stock play, it's a investment play for this third party company.
Oh. So Chelsea, as coverage counsel, what are your concerns with third party litigation funding?
So as a coverage counsel, my concern is always, how am I gonna get my own client coverage for the defense, which is paid for usually by an insurance company. So setting that aside, one of the issues that comes up with these third-party litigation funders is the concerns about attorney-client privilege and protection of work product as among the funder, the attorney, and the actual client. And what it does for the defense side, which usually the policyholder is looking for a defense and they're looking to go after, they're looking to, suss out any information they can get from the plaintiff side. In some states, the litigation funder doesn't get the privilege of protecting confidential information about the client. And so it will come into play in terms of how defense counsel will consider certain types of discovery, what kinds of information that they would ask for, maybe that they'll ask for information directly from the litigation funder, and so on.
Okay. So
And
Michael,
Shannon,
yeah, go ahead.
I just want to throw on top of what we're talking about so
Yeah.
people understand it, because it is such a relatively new situation.
Yeah.
Where they're putting this funding is they're backing it in counties and states in where judicial hellholes are at. So it's compounding the marketplace to say, hey, we're going to put money to where favorable lawsuits were going to go towards the plaintiff bar. And that's the legal system is trying to catch up to it. So states like Indiana, Louisiana, West Virginia, and Florida are trying to implement laws to try and like make it either have to publicly known that third party litigation funding is available, but we're also looking at a federal level. So it's so new that the carriers are trying to catch up to this, and that's why it's such a prevalent talking point right now. Sorry.
Yeah, no, I agree. It's advancing cases that wouldn't ordinarily advance potentially, and you're right. Those transparency laws are definitely in the works, trying to at least let people involved know that third-party litigation funding, is a part of that case. So Michael, as defense counsel, do you have any additional concerns that you want to voice?
Yeah, I mean, to touch on kind of both topics, I mean, to dovetail on what Scott said, with the amount of money that's pouring into these lawsuits and that is funding the plaintiffs, it does increase the potential exposure because these plaintiffs are taking in and the lawyers are taking in essentially quote unquote free money. That loan or the funding could be, tens of thousands and in some cases, hundreds of thousands of dollars. And that takes the incentive away for the plaintiff or the law firm to settle if they know there's a big lien on that and that the amount or the award needs to be driven up. So that's one consideration. And then to kind of build on what Chelsea stated, even though it's not directly related to third-party funding, I think it's important on the issues of confidentiality and privilege that if you find yourself in litigation, be very careful with who you're communicating with. I'm talking both in terms internally within your organization and with a co-defendant that you may think is friendly to you, that your interests are aligned. I can't tell you the number of times I've gotten into a case and you've got, business to business communications with co-defendants, and company A representative thinks he's having or she's having an offline conversation with a representative of company B. And again, I've seen this. It was only a matter of time before this happened. We all knew it was coming. And you think, well, we're in litigation, it's privileged. Well, no, not necessarily. And then same thing internally. I've had communications where, an executive is sending something to employees and employees are communicating. And the advice I'd give everybody is if you're in a lawsuit, expect any email that you send is going to be slid back across the table at you in a deposition. So be very careful about what you put into that. And then just the last thing I'll state is just because you copy a lawyer on an email doesn't necessarily mean it's attorney-client privileged. I've had clients where they will copy me on something that has nothing to do with the litigation, but they want to think that it's privileged. So they'll copy me and I'll have to pick up the phone and say, what you just sent just by copying me doesn't make it privileged. So if you're going to do that, again, keeping with what I brought up earlier, make sure you're communicating with your lawyers. And if nothing else, if you're going to send an email and copy your lawyer, make sure that your opening line is on the advice of counsel or at the direction of my lawyer, I am sending you this. And that at least gives it one more protection. But those are very important things to keep in mind.
Yeah, I agree. We at the Miller Group, as an insurance broker, try to be really careful of that too, because we have a claims department that's here to advocate for our clients. But we want to help and we want to keep things going, but we certainly don't want to break that attorney-client privilege either. So we do have to be careful. I agree. So there's a third and final term I do want to define real quick too. It's called reptile theory. So Michael, would you mind defining that and just explaining how it influences jurors?
Yeah, absolutely. So the reptile theory is a litigation tactic that was developed in 2009. It started as a book or in a book by some consultants and lawyers who wanted to drive up the value of their cases. And what it is designed to do is to appeal to a jury's survival instinct. And it's to elicit a response from what's called the reptilian part of your brain, which governs everybody's instincts, governs their instinct for survival and safety. It's been a routine practice in the transportation industry since 2009, 2010, and has developed and really gained steam. In every single trucking case I've got, reptile theory is deployed. But I'm now finding in my retail and hospitality cases that it's happening. In construction cases, it's happening. In my auto cases, it's happening. And what it does, and the purpose behind it, is to paint the defendant as a threat to the community, particularly with respect to safety. It encourages the jury to act as a gatekeeper and protect the community and be the arbiter of what is safe and not safe. And then what drives up the award is the explanation that, you ladies and gentlemen, as the jurors, the only way that you can send a message and protect the community is to deliver a message with the amount of money you're rewarding to this particular plaintiff. It's a very simple yet effective strategy, and it starts usually in the deposition of whatever employee was at fault for whatever incident, whether it's a driver, whether it's a foreman, whether it's just a service clerk. I mean, you name it, that's number one. Number two is the corporate representative, the face of the company. And it starts in those two depositions. And it's again, a very simple technique, and it starts with very broad and vague questions that you want to say yes to. And then once you get that yes response, you are locked into that particular response and you can't explain away what happened in your case. And it starts with defining a rule. That can be a company rule, it can be an OSHA rule, it can be a Federal Motor Carrier Safety Regulation rule, it can be a rule of the road that's in every driver's manual. And the line of thinking or the line of questioning is, you agree that whatever rule they are talking about, it's a safety rule. And your instinct is to say yes. And that rule is designed to keep people safe. Yes. And because safety is the top priority of ABC company, that's why they implemented this rule. Yes. And if your rules are followed, the public is safe. Yes. If your rules aren't followed, then the public is endangered. Yes. And your employees should never violate the rules. Yes. Well, now you're locked in to there's no explanation for anything else. And as soon as the lawyer gets yeses to those questions, he or she then goes into the facts of the case. And it's, your rule was designed for the public in mind, and nobody should ever violate it. Well, your employee violated it. Well, now when you try to explain it away, the lawyer says, excuse me, sir, excuse me, ma'am, 3 minutes ago that you said your employee should always follow those rules. And if they don't, they'll endanger the public. And I mean, we could do another hour seminar on how to prepare for the reptile theory, but there are ways to combat it. It takes a lot of prep, it takes a lot of training. If you are ever in a situation where you are going to give a deposition and you are in a personal injury case, ask the lawyer that's defending you about the reptile theory. Does this lawyer implement it? Let's prepare for it. If that lawyer doesn't know what the reptile theory is, doesn't want to prepare you for it, insist on it. You know, call your broker, call your insurance carrier, talk about your concerns with that attorney. Bring it up with the attorney. I mean, say I went to a webinar on this issue and I'm really concerned about it. And then again, if your lawyer wants to prepare you for a reptile theory, you need to put in the work. If this isn't going to be all right, come in and meet with me for 30 minutes and then let's send you on your deposition tomorrow. For me, it's a half day, maybe even all day initial preparation, then another practice session. So kind of keeping with the theme I've talked about is if you find yourself in these situations, make sure you're working with your counsel to make sure you're prepared to address any situation that may arise.
Yeah, that's great advice. So let's shift the conversation to what's going on in the court system. So specifically the choice of settling versus going to court. So Michael, sticking with you as a defense attorney here, could you share what you're hearing from your clients as they weigh that decision?
Yeah, I mean, the biggest drawback or the biggest risk to taking a case to trial is a nuclear verdict. It's what we're here to talk about. I mean, you drive down the highway and you see 10 million this, 15 million this, $100 million this. You turn on the TV and it's, I got a $300,000 verdict for a low impact accident. And so we're seeing a lot of these jury awards and settlements are being influenced by advertising. I mean, one of the lawyers that's in Missouri put billboards up on every entrance to the Jackson County Courthouse talking about his $10 million verdict, which anybody who is in the legal community knows that that really wasn't a $10 million verdict. It was a lay down defense verdict where the insurance company had already tendered its million, but he wanted that $10 million number to advertise. It's also, since COVID, you've seen a large rise in jury verdicts. There's a lot of social factors behind it, and I've been to a lot of conferences on it. It's just the anger and the isolation and things that people have felt during COVID, which leads into the reptile theory, which wants people to be, you know, the arbiters of safety. It also, I think, goes into just the numbers that have been thrown around, and you know what the spending in COVID. You have athlete salaries. You have Patrick Mahomes making $500 million, and those numbers aren't desensitizing people anymore. It's just run of the mill. And I'm not going to sugarcoat things. Going to trial is risky. You know, it's easy for me to say, hey, we should take this case to trial, knowing that if the verdict goes poorly, it's not my money. I mean, I'm very cognizant of that fact. But I try to work closely with my clients and with the insurance carriers, and I would encourage anybody listening to do the same, to really analyze what's your potential exposure. And I also can appreciate that settlements are driven by a cost benefit analysis, that it's going to cost me X to try the case, or I can settle it for Y. Y is less than X. I'm saving money in the long run. And that is a completely rational line of thinking. But several plaintiff lawyers I know in Missouri will bring cases that they know, baseless is the wrong word. I mean, they have a reasonable basis to file the suit, but they know liability is tough, damages are tough. And they're taking a bet that almost any case in Missouri is worth $25,000, because it's easier to pay $25,000 in settlement than it is $30,000, $40,000, $50,000 to go to trial. You know, my kind of knee jerk to it is I think the defense side needs more wins. We need more published verdicts, published results. I think we need more cases that are taken to trial. And again, it's easy for me to say that it's easier to go to trial and spend more than you could to settle it. But until we start doing that as an industry, the numbers are going to keep going up and up and up and up. And we just have to pick the right case to do it.
Yeah, I agree. So Chelsea, in your role, you know, holding insurance carriers accountable, what's your perspective here?
Sure. And I completely agree with everything that Michael had to say. I do think that From the policyholder's perspective, there are lots of factors that go into deciding whether they want to push for a settlement or not. Michael mentioned a few of them, including the cost of trying the case if you're not being defended by your insurance company, depending on the policy terms, et cetera. There might be other issues like the impact to your business that it's coming up because of the fact that everyone has to be in your small business, everyone has to be at a deposition or a trial or et cetera. Those are real concerns for companies and can come up. So what I talk to my clients about, and I work very closely with defense counsel like Michael to make these evaluations, is first of all, we're always looking at, is the insurance company the decision maker or is it the policyholder? And it really depends on the policy language and then what the insurance company has done thus far. Are they driving the bus because they've taken on the claim, or have they denied, somehow reserved their rights and said, we'll defend you, but we're not sure if we're going to pay a judgment if it comes to that. In that case, the insurance or the policyholder is driving the bus more often, making the final decisions on whether to settle and also whether to push for settlement money from the insurance company. And we're always working closely with defense counsel to kind of gauge how can we get to a point where the insurance company will pay a reasonable settlement that makes sense in this case. What are the concerns if this goes to trial? Is there a chance that we're going to be in an excess verdict situation? The very kind of nuclear verdict that we're talking about today, where you have coverage, but it only covers so much of the expected verdict. Those are all coming into that, analysis. I will say from the insurance perspective, they don't cover damage to your reputation or damage to your business per se, because of these verdicts. And so that's not part of their analysis. So what my job is, I come in to work with the client and the defense counsel to set up the best case for getting the insurance company to pay that settlement for the legal reasons that they're on the hook, even though I know that some of the reason the client really wants it is something like the potential damage to reputation.
Yeah.
And
Yeah.
on that, and I don't mean to jump in, but for those listening, I mean, and to try to generate some conversation, I mean, I'd throw into the chat, I mean, what are you all considering when you're involved in litigation, whether you're an insured or you may have some role in the decision of what gets spent? Is it just a cost benefit? Is it just dollars to dollars? Are we going to spend less settling it than we would on counsel fees? Are you looking at your reputation? I mean, honestly, I'd be interested because I think the more people that can contribute and talk about the pressure points and what considerations go into settling versus going to trial, the better it makes us all at our jobs.
Yeah, I agree. And that, reputational harm can be revenue for a for-profit company, and it could be grants or funding or donations for a nonprofit, right? It can be so many different things. So it's not a black and white decision by any means. So let's shift to Scott here for a second. And so Scott, what does all of this have to do with insurance? How does this impact the insurance industry?
I mean, so you have to look at the insurance industry as it's a for-profit industry. So everybody's here trying to make money. And with the robust amount of claims and the nuclear verdicts that are coming down the pipeline, they're trying to juggle, how do we make money? And twofold. One, where Michael's like, hey, we want more claims to go to court. Well, the backdrop of that, if I'm an insurance carrier, when you guys read your policy, there's a ton of endorsements, there's a ton of exclusions. They don't know how all of them are going to react in a court of law, whether they're going to have coverage or not have coverage. So when you get a final verdict, you now have actual data to say that endorsement either holds up or does not hold up in a court of law. So they're afraid of, is there language that they write their policies, are they going to have to pay or not pay? So that's a big determination of like, hey, do they even want it to go to court? Secondly, when you're an insurance carrier, you've got to look at it two ways. when you've got a plaintiff lawyers, they're all meeting together, they're going to conferences together, they're talking about what they're doing, what they won. We talk about reptile theory. I'm not a lawyer, but obviously that was built over time to come up with that as a thought process. It wasn't just one person. When you're a carrier lawyer, you're just talking to yourself. So you only have the data that you have on hand. And, carriers are not exchanging their loss, how they're attacking losses like the plaintiff lawyers are. So a lot of these carriers are behind the eight ball because they don't have as much information as the plaintiff lawyers. And then the last part about it is because of nuclear verdicts, there's a lot of carriers on a policy at this point. So if you have got 4 carriers, you got 4 claims department fighting or talking to each other, and to get them all on the same page is somewhat tough because if you're the top layer, all you care about is settling it below it gets to your layer. Where the lower layers are like, hey, we know it's blowing past our limits, and they just want to get their money paid. So these are all things that the insurance industry is talking about when you hear Michael and Chelsea talk about what they're doing. So now we've got to go back to profitability. These claims are showing that, if you've been in an industry 10 plus years, you may have been getting a general liability limit of a 2 million and then a 10 million or 25 million excess from one carrier. Well, those started getting hit around the COVID years to now because of nuclear verdicts in classes of business that the carriers were not expecting. So now we're having multiple carriers make up the limits that you buy. So that's going to affect their rating basis, how much limits they can put out there. So it's why you get a lot of questions about maybe your fleet size, your radius of how far you drive. Again, back to what states are you involved in? What classes of business are you physically involved in? Because some people like to put on a website that they do everything, and really they only do X, Y, and Z. Well, we want to make sure we're underwriting what you physically do. So all of these are coming into play of like, hey, we want to make sure we have your true exposure so we can figure out profitably what kind of limits we can put out for you, what kind of rates can we charge you to make it that you're staying in business and able to thrive and be competitive, and whether it's a bid situation to be in your industry, but also realizing that like if we do have a claim that we're going to want to defend you and keep you on past this first claim because we know you do all the right things to make you a great customer for the insurance carrier.
Yep. Great point, Scott. So Chelsea, you had made reference earlier to, that verdicts aren't necessarily covered in their entirety by insurance. So what can a business do if their insurance coverage does not cost the full coverage or the full cost of a verdict?
Right. So this is where, that cost benefit analysis, that risk analysis that we were just talking about comes into play in terms of whether you are going to push for a settlement or not. If there's I'll work very closely again with defense counsel. And if the defense counsel has assessed there is a chance of a nuclear verdict, and what I'm talking about in this situation is that verdict, you have insurance for $1 million in primary and $5 million in excess, but the verdict could be 10 million. You don't have enough coverage for 10 million. Can you afford that delta? And if that happens, and if you can't, what are we going to do about that? And in that case, often when you have that exposure to a potential excess verdict, then we're looking at options for forcing the insurance company to cover. Many states have requirements that they take into consideration that potential exposure. The insurance company take that into consideration when thinking about a settlement. And if they don't, if we set up the facts correctly and we understand all the aspects and we understand the coverage that's available, there is a potential of suing in bad faith, right? So this is a term that many people have heard of, but what we're saying is the insurance company hasn't met the standards of good faith that are owed to an insured or a policyholder, and that comes in addition to just the basic contract requirements. It's a requirement that the insurance company is at least weighing equal to their interests, the policyholder's interests. And if they're not doing that, and we have reason to believe they're not doing it because of the position they're taking in a settlement discussion, then we can think about filing a bad faith action if it's appropriate and makes sense. And that things that come into play in that decision making is, do you want to be fighting two wars at the same time? Is there a potential of recovering your fees if you win the insurance question? In many states there is. And so then, you pay out of pocket up front, but then the insurance company is on the hook at the end. That's not true in every state, and sometimes there are limitations, but we're always kind of thinking through those options and whether that litigation to force the insurance company to do its job is an appropriate thing at this time. Obviously, the other option is if you have the money and you want to roll the dice on trial, and you know that you can cover an excess verdict, then that comes into the analysis, and you just need to be prepared that the insurance company isn't going to just pay. They're not going to pay anything more than they have to, and if their insurance says they cover 5 million, that's what they're paying. If you get a verdict of 10 million, they're not paying it the other 5 million.
Yeah. So it's a really important decision as far as what, amount of limits you purchase. So Scott, what do you hear from businesses as they're weighing that decision of how much limit to purchase?
I mean, we're hearing a lot of businesses struggling with buying higher limits because of the price that it comes. So overall, they're having to weigh, staying in business versus buying large limits. And a lot of them are scared to buy higher limits because they're like, hey, they're only going to sue for the amount that is in my policy. And that can be true, but that doesn't necessarily always be true. So you have to weigh, as we've talked about before in previous discussions, where they're trying to look at what you have financially as a company to make sure you're properly insuring yourself for harm done to the general public.
Yeah, we hear that a lot too. Chelsea, what's your response to that as far as how much you purchase is how much you're sued for?
Yeah, I mean, I think Michael might be able to address this as well, but my concern is always, as the policyholder representative, I want you to have the most coverage you can. And I want that to cover your potential loss. And so my advice is often to look at what the likelihood of an excess verdict is. And if that's the case, then maybe look at ways to reduce costs with other endorsements or other exclusions.
Mm-hmm. Michael, what were your thoughts?
Yeah, I mean, they're both right. It's a hard balancing act between how much insurance do I buy and, not spend so much money on insurance that I'm overinsured, but also making sure that I have enough insurance where if something catastrophic happens, the insurance is there to protect me. As far as I've got clients everywhere from, $500,000 SIRs that, they're paying most of it out of pocket to they've got towers of insurance up to 100 and to 150 million. And yes, every demand nowadays that you're going to get is going to be for your policy limits. If it's 1, if it's 10, if it's 150, because that's just the opening demand. So while there's some concern and some thought that needs to be given to that, I always come back to, your business best, the people you work with best. So have that honest conversation with them. As defense counsel, it can sometimes be a contentious relationship because I and other defense counsel are hired to represent the insured. They're our client. We have to act what's in their best interest. The insurance company is paying our bills, and we have duties to the insurance company to report and to make sure we're keeping them advised. But at the end of the day, our duty goes to the insured. And when we get involved in these policy limits and how much insurance, et cetera, we can't advise people on that, cannot. I can't tell the insurance company, hey, this is what you should do in connection with this policy limits demand. I can't tell the insured, this is what you should do in connection with this policy limits demand. What I can do is tell you, this is what I think the claim is worth. Here's the pressure points. Here's your pros. Here's your cons. And if you go to trial, this is the range that I think that jury verdict's going to come down in. And I've, again, settled cases where the insured absolutely demanded that it get settled and work directly with the insurance company, and the case gets settled, and they call me 6 months later at renewal time, my premiums just went up. Why'd that? That's not my not my ability to get into that. And I've had it the exact opposite way where, folks don't really care what the implication is to their premiums. They want that case settled, going back to a lot of the considerations we talked about earlier. Um, the last thing is when you're purchasing insurance and having these discussions with your insurance provider is honestly think about what your risk and exposure is. I've also had cases where I've represented companies that have had, you name it, 1 million or 2 million in insurance and a catastrophic loss happens. And the plaintiff lawyer saying, I'm not going to take that million. I'm not going to take the 2 million. I want a pound of flesh from the company. I've looked at their balance sheet. I got it in discovery. I know that they've got 6, 7, 8, 10 times, in profit what this insurance will provide, and I want them to pay. So that goes back to having that honest conversation with your lawyers and your brokers and anybody else who's advising you on these issues to find out what those pressure points are in advance.
Yeah, I agree. It's a tough decision. And, so many of our clients want to know what limits to buy. And they're like, well, what are my peers doing? Or, and that benchmarking is helpful, right? But at the end of the day, we're protecting your balance sheet. And I want to know what keeps you up at night. And the more I know about your operations and how those change, the more I can give you better advice, right? On what limits might be appropriate based again upon what you're doing and where you're doing it and everything we talked about earlier. So, in the insurance market, we're seeing a continuing trend where claim costs rise year after year, but the limits purchased are either staying the same or sometimes, being reduced, which is understandable. We've been in a hard market, costs are high, we get that, but that gap between claim costs and limits purchased is growing year after year, so it's concerning. All right, so we've talked about a lot of scary concerns today. So let's shift to what we can do to protect your company. So Michael, what's your advice? How can companies protect themselves?
Yeah, it starts for me with getting your procedures in place before you ever get into litigation. If you have a policy and procedure manual, it's put into place for a reason. Don't rush through that process. Don't go online and say, I'm a construction company. Can I find what is online? Can AI draft it for me? Or I know somebody at a potential competitor of mine, but they're friends. Hey, give me your policy and procedure handbook so I can look at it and implement it for my company. Not saying that those aren't valuable resources, but if you're going to do that, don't just take a policy and plug it into your business. Take the time to analyze it, to discuss with whether it's folks internally, if you have an in-house counsel, talk with outside counsel, work with your insurance folks to make sure that what you were putting in place matches your company. I can't tell you the number of times I've started, in depositions on the reptile theory, and they talk about whatever rule it is. Why was this implemented? I don't know. I found it online, or I borrowed this from company B. Oh, so you don't even care about safety enough to draft your own. You're just cutting and pasting. So start there. Um, if you have something in place that requires you to monitor your employees, follow it. If your policies and procedures talk about monitoring speed, monitoring GPS, monitoring internet history, whatever the case is, if you've got something in place, you better be monitoring it. I get into this with dash cam. I've got clients that they get 10-second clips every time there's a near miss. What do you do with that? Well, nothing. Well, so as soon as a lawsuit happens, it's so you have hundreds of hours of your employees almost rear-ending people or your employees doing a dangerous act and you've done nothing. Well, yeah, that's right. Well, there's another arrow that the plaintiff's lawyers can sling at you. Um, I know and I appreciate every single industry that I am involved in where I represent clients. It's hard to find good people. And once you find them, it's hard to retain them. And so when you get people that are really, really good, you want to keep them. Don't let that outweigh following your procedures with these folks. If it's a really, really good employee, but your policy says you must be terminated if you do Y, you better have serious thoughts about terminating that employee if they engage in that behavior. It's usually not the first incident that's going to happen, it's the second. And it doesn't even have to be for the same behavior. I've had cases where an employee should have been fired because he or she exceeded the speed limit by 15 miles per hour and then were involved in a rear end collision. One has nothing to do with the other, but the lawyer's argument is, well, you should not have been working for that company. You shouldn't have been on the road. So really look at your policies and procedures, make sure they fit your company, and make sure that you are monitoring. Um, Once litigation starts, the biggest issue that I run into is companies not taking it, they take it seriously, but they don't put in the time. I'll call for, I need to speak with such and such employee. He or she's busy. They're real jammed up. You can't meet with them. Well, their deposition's in a month. I really need to meet with them. Sorry, can't do it. What time's the deposition for? 10 o'clock? Great. She'll be there at 9. That hour of prep does nothing to prepare for a deposition that's coming. And then when that employee gets absolutely massacred by the plaintiff lawyer, well, why did you let that happen? It's not me that let it happen. I've been asking you for a month to get me time with that person. If it's finding documents and records that were requested in discovery, make sure that you're going through the time to do that and you're working with your lawyers. The number of times where I've said something didn't exist or said that this information couldn't be found just for in a deposition for somebody to say, oh no, we've got that manual, or yeah, I've got that information. Then you're finding a whole nother set of issues for spoliation and discovery abuses. So kind of getting back to the theme I started with, make sure that you are working with your lawyers, with your insurance carriers, with your brokers, treating them as teammates. I mean, and if your lawyer, broker, carrier is not involving you in every step of the litigation, or at least reaching out to you, raise hell. I mean, ask questions, send emails, demand to get involved, because the more that you can be involved and the more that you can be a part of the process, the more that you can help plan, the more that you can be involved in those discussions to mitigate risk, to lower the potential verdict or nuclear verdict or whatever it is. So that would be my biggest takeaway to everybody listening is I don't like talking to lawyers either. I get it. It can be a pain. It can take time out of your day. It's why are you asking me 1,000 questions when 5 will do? Why are you still rambling like I am now? I mean, it's just it's part of the process, and everything that your lawyers are doing are for a reason. And if you don't treat them and your brokers and your insurance providers as a teammate, as somebody that you need to work with in these situations, you're doing yourself a disservice.
That's great advice. Chelsea, what would your advice be?
Yeah, from the insurance perspective, my first piece of advice is actually to pull in coverage counsel like myself or others who do the kind of work I do when it's appropriate. You don't need me all the time. You may not need me at all in certain cases, but knowing when you need to put pressure on an insurance company and your defense counsel, like Michael said, can't step in that situation. I don't recommend taking it laying down from an insurance company. Have someone on your side that can come out fighting for you and trying to get as much coverage available for those verdicts as possible. If you're placing coverage, I know that Scott will touch on this a little bit, but a couple things to keep in mind is to be upfront with your broker and on your application for coverage. There's often a disclosures section. There's questions that are asked. Make sure you're going through that carefully with your broker and honestly answering those questions. The worst case scenario for me is when I show up on a case and my client has received a denial letter because they didn't disclose something on the application, and now the insurance company is taking the position that it's not covered at all because you weren't honest in the application. So the insurance is effectively void. That's not a good scenario to be in. There may be arguments around that, but you don't want to be fighting that fight while you're also defending your potential nuclear verdict. And then also understand the requirements of your policy in terms of giving notice. Your broker can be a good resource for this. Coverage counsel can also help with this question, but you might have an incident, we'll call it an incident, that occurs and there's no claim made right away. And there are questions and certain policies about, when you have to give notice to the insurance company of that incident, even if there's no actual claim. When you do actually get a claim, someone is demanding some sort of, recompense for the injury that occurred, then, or the alleged injury in some cases, then, what do you have to disclose to your insurance company? When do you bring your insurance in? I know people talk about this with their car insurance. Oh, well, this one I'll just cover out of pocket and not even notice my insurance company. When it comes to your business, I often don't recommend that. That's not usually the right way to go, because if there is even a 15% chance, I don't know, I'm not saying one way or another, but if there's a chance for that nuclear verdict, you want the insurance company in partnering with you from the beginning. And if they're not going to partner, you want to know right away so that you can bring in the right resources to get them on board.
Yeah, I agree. Something that might seem small could turn into a big catastrophe. And if you don't have them on board with you, then that might all be on you. So that's great advice. Scott, from a broker's perspective, what's your advice here?
I mean, to piggyback what Chelsea said, first of all, start with be honest about what you do in every aspect. Be as forefront, like if you're in the industry, be in the industry and talk to your broker throughout the year, not just that renewal time, not just like 30 days out, throughout the year. If you're changing your operations, what are you changing? Keep them abreast. Secondly, talk to your broker about what drives the losses in your industry. And if there's things going on in the industry that are going to help you from a safety standpoint to help drive down losses, drive cam wasn't always around. Now it's around for everybody. At one point, somebody had to say, I'm going to start putting drive cam in all my trucks. Well, talk to your broker about, if you're a trucking company, what else can I do besides drive cam? If you're in construction, maybe it's a subcontractor warranty product. Maybe it's a tracking device for certificates to make sure that, like, hey, you're transferring all the right risk and having the right verbiage. But it's talking to your broker throughout the year of like, hey, what are the drivers of losses and what is being implemented new that will help present me better to the marketplace? And if you're in an industry that's tough, but you're doing all the right stuff and you're the best of the best, talk to your broker about retentions, because hey, if you're doing all the right things and you have the funds to back it up, you may want to take a higher retention and show the carriers, because some of these carriers don't want to be down low and offer a guaranteed cost program. They want you to have skin in the game, and they want you to put your money where your mouth is and say, hey, we'll give you way more aggressive rates because you're willing to take the first $5,000 deductible, $250,000 deductible, $500,000, whatever the number is. But they're saying, like, hey, you really do believe in your product. We're going to believe in you more because you're invested in it. So all these items of believing that your industry, that what drives the losses, and you're doing as much as you can to combat losses for when they do come around, are all great ideas to be able to put in front of a carrier to partner. And then lastly, get to know your underwriters get to know the underwriters in your industry. So like, hey, if they're presenting a quote, they can put a face to a name, and they can say like, hey, we actually know this person, and like, hey, we do believe that they are doing all the things that they say they're going to do.
Yeah, I agree. Betting on yourself is always the best thing you can do if you've got that safety and that loss control there. And then taking those higher retentions, taking the savings from that, and continuing to invest in your safety and your loss control. It's a great way to keep your premiums down. I think we're pretty close to time, Amanda. Do we have any questions from the audience?
We have one. When Michael spoke about how settling out of court was driving up, or not, I might be speaking misspell. I might be misspeaking, but does settling actually encourage more claims because it's viewed as free money?
Yeah, I think that is certainly a potential, yes. And I think that the way I approach things is, I don't run your business. I don't know your pressure points. I don't know your particular business's personality. So I'd start with, If you have a mindset that we do not want to settle cases, we want to take everything to the mat, work with your broker, work with your insurance carrier to make sure that you get a framework in place that works for you. Whether, as Scott said, that may be dealing with higher deductibles or self-insured retentions or whatever the case may be. If your company is more of it's nothing but the bottom line and it's about saving money, then yes, it may make sense to settle those claims. And I represent clients, both insurance carriers and self-insured folks that take exact opposites of the spectrum. You've got insurance clients that will not take cases to trial. I've got insurance clients that say, we'll take cases to trial if it makes sense. Same thing with companies. I do know that the plaintiff bar talks in every single state, and whatever is out there, they will get information on your company. Sometimes it does, even though you are encouraging more lawsuits or more claims, the fact that the plaintiff lawyer, hey, look, we can settle it quick, your claim open and closure rates may go down. I mean, there's a lot of different factors. So I know I sound like a broken record, but just make sure that you are in constant communication with your partners on these issues.
Real quick, we're about to run out of time. We did get one more question come in, and this will be our last one before we wrap up. But before we get to the question, if you happen to have a question that you didn't get to ask today, a follow-up email will be sent. So you'll have our contact information. So, but the question is, how would you recommend handling a difference in settling a claim between the insured and the carrier?
If I'm understanding that one, if it's a claim from an insured against their carrier, I don't necessarily get involved in that. Chelsea, you probably handle more
That's
of that.
me.
Well, I know you do handle more of that than I do.
Yeah, I mean, so if you have made a claim and ultimately had to litigate that claim against your insurance carrier, there are a lot of factors, again, in terms of when or whether to settle. And it will depend in part on whether you have a judgment or a settlement in that underlying liability. Is there something to base that concept on? Oh, no, the insured does not want to settle, but the carrier does. That comes down in part to the contract language. If the insurance contract will control who's driving the bus at that time when it comes to decision making on a settlement. It will also come down to what the insurance carrier has done up to that point. Have they taken have they taken the claim in full and said, yep, we'll cover whatever it takes, both the defense and a potential judgment? Then they may be the one driving the bus and they get to make that decision regardless. You may have some input into that decision making, and certainly you're working with your defense attorney on that input and how you present that to the carrier. But it really kind of depends on the circumstances, and sometimes that's another time when you need coverage counsel to make your arguments for why you need to stay the course in this instance. So it really, I know I sound like a lawyer, but it depends.
Well, you are a lawyer, so that makes sense. Makes sense. Shannon, before we wrap up, do you have any last words that you want to say?
I don't. I just really appreciate everyone's conversation today. It's a multifaceted situation, and there's no black and white, but it's great to have good partners in your corner, right?
Absolutely.
Exactly.
Thank you, everybody. Thank you to Shannon, Chelsea, Scott, Michael. Thank you to everybody for attending. This was a great conversation. We will be sending out a link to the recording. So thank you all and have a wonderful afternoon.